Hi, this is Blaine Cluten for Cluten Law. The question is, do I need a trust or a will? And what I'd like to first just say is, do I need a trust or a will? The answer is yes, but that's not the question. The question is, should I have a trust or should I have a will if all things are equal? Really, the answer to this is going to depend, and I know you have heard that a lot, but depending on your facts and circumstances, you need to talk to an attorney and find out what's going to be best for your situation. But let's just speak real generally about this. The nice thing about a will is it's a set it and forget it. Any assets that you have, wherever they are, you are dictating that they're going to be distributed in a certain way once you pass away. And so if you later acquire certain property or you buy and sell property throughout your lifetime, it doesn't matter. There's no impact on anything. Wherever you have, wherever it is so situated, that's what your will is going to devise that you're bequeathing to the other folks that are included in your will as beneficiaries. The difference between a will then and a trust is a trust designates certain property that's going to pass to those specific beneficiaries. So if, for instance, you have real property, you're going to retitle it, redeed it into the name of the trust rather than in your own name so that you are the beneficiary of that property under the trust when it's initially created, so you can continue to use and enjoy it. And in reality, you can still dispose of it because you're still the beneficiary under the will, the trustee and the trustor. But once you pass away, there are successor beneficiaries, successor trustees that then take over the disposition of that property. And because the property is held in the name of the trust, it does not require it to be retitled, redeeded into the those beneficiaries' names. It's already in the name of the trust, and that's kind of the benefit, the cool thing about a trust. The problem is, though, with a trust is that anytime you buy or sell property, you've got to make sure you're getting it into the name of the trust. Otherwise, if you don't, when you pass away, you're going to defeat the purpose of the trust, and that property that hasn't been included or was not put into the name of the trust while you were living is now going to have to be probated and dealt with after you pass away through probate, because it's still going to be held in your name. There's some other properties that are kind of like this, but the point is that usually the time when you're creating a trust is usually later in life when you're done buying and selling properties. You basically own what you're going to own. You're not buying and selling anymore. Everything's pretty well set, as opposed to a will where you're continuing to be able to buy and sell, and it's not, the will itself is not affected if you buy or sell something. So that's the basic overview of, do you need the will or the trust? But again, the first thing that I mentioned was you should talk to an attorney, because circumstances are going to vary, and the answer about whether you should have a will or a trust is going to vary, and it's going to be kind of a case-by-case basis. So that's why you should talk to an attorney. This is Blaine Cluten for Cluten Law. Thank you.